court then turned to Article 177, which addressed the election of the president. Article 177 2b states that a person is deemed to be elected as president when, quote, more votes are cast in favor of the list in which that person is designated as presidential candidate than in favor of any other list, unquote. The president is deemed to have been elected because in Guyana's electoral system, an elector's single ballot is rarely cast in favor of a list of candidates. There is now no separate election of a president, as there used to be in earlier times when the president was elected by the votes of the members of the National Assembly who had already been elected to that body. Article 177.4 was always intended to operate after the president had been elected. This was the case when, originally, the president was elected by members of the National Assembly, and it is so today, when the president is deemed and declared to be president after it is determined that more votes were cast in favor of the list in which she or he was designated as a presidential candidate than in favor of any other list. Questions as to the validity of the president's election under Article 177 were never intended to impugn or relate to the validity of ballots cast by electors at the election of members of the National Assembly. Article 177.4 only affords jurisdiction to the Court of Appeal if the question raised as to the validity of an election of a president depends upon the qualification of any person for election or on the interpretation of the Constitution. It is evident from the nature of Ms. David's complaints and the issues she placed before the Court of Appeal that the questions raised by her did not depend on the qualification of any person for election or on the interpretation of the Constitution. Ms. Davis' complaint was really about the impact of Order 60 and about the conduct of GCOM. What the Court of Appeal majority did was to embark upon an exercise of interpreting Order 60. The Court of Appeal majority considered the effect of Order 60 on the responsibilities of GCOM and then applied that to the clear words of Article 177.2b. Article 177.2b, in fact, required no refinement. That article, in plain and simple language, has always said what it meant and meant what it said. There was no need for an interpretation of that article or any other article of the Constitution. Accordingly, there was nothing in Ms. David's application to trigger the Court of Appeal's jurisdiction under Article 177.4. The Court of Appeal lacked jurisdiction to make the orders that were made. Those orders were not made under Article 177.4 of the Constitution. Counsel for Ms. David also suggested that because the Court of Appeal had interpreted the words of Article 177.2b, quote, more votes cast, unquote, and concluded that those words really meant, quote, more valid votes are cast, that their decision then fell within the purview of Article 177.4. The court did not accept that argument. The concept of, quote, valid votes, unquote, is well known to the legislative framework governing the electoral process. The concept has a particular meaning in that context. The phrase appears several times in the Representation of the People Act, including in Section 96 of that Act. That section, Section 96, calls on the Chief Election Officer to calculate the total number of valid votes of electors which have been cast for each list of candidates. Validity in this context means and could only mean those votes that on their face are valid. The determination of such validity is a transparent exercise that weeds out of the process, for example, spoilt or rejected ballots. This is an exercise conducted in the presence of the duly appointed candidates and counting agents of contesting parties. It is after such invalid votes are weeded out that the remaining valid votes count towards the determination of not only the members of the National Assembly, but incidentally as well, the various listed presidential candidates. If the integrity of a ballot or the manner in which a vote was procured is questioned beyond this transparent validation exercise, say because of some fundamental irregularity, such as those alleged by Mr. Harmon, then that would be a matter that must be pursued through Article 163 after the elections have been concluded and the victors declared. At the point in the electoral process where Article 177(2)(b) is reached, there is no further need to reference valid votes because, subject to Article 163, which is triggered by election petition after the election, the relevant validation process has already been completed. By the unnecessary insertion into Article 177(2)(b) of the word valid, the Court of Appeal impliedly invited the CEO to engage unilaterally in a further and unlawful validation exercise that trespassed on the exclusive jurisdiction of the High Court established by Article 163. It was inconsistent with the constitutional framework for the CEO or GCOM to disenfranchise tens of thousands of electors in a seemingly non-transparent and arbitrary manner without the due processes established in Article 163 and the Validation Act. For all these reasons, the court adjudged that the provisions of Article 177(4) were not triggered by Ms. David's application to the Court of Appeal. Since the Court of Appeal had no jurisdiction to hear the application brought by her, the finality clause in Article 177(2)(b), in 177(4), was inoperable, and under the laws of Guyana, this court had jurisdiction to hear and determine the application by Messrs. Ali and Jagdeo and to set aside the decision of the Court of Appeal. This court was also entitled and required to declare invalid the report issued by the CEO, which was based on the decision of the Court of Appeal. It follows that the appeal of Messrs. Ali and Jagdeo succeeds.